Jasmine Crockett stood at the center of the Supreme Court chamber, the formal symmetry of the room pressing in from every direction. Bright overhead lights reflected off polished marble, illuminating her red suit in stark contrast to the black robes surrounding her. Her heart was pounding, but her expression remained steady, deliberate. Seconds earlier, Chief Justice John Roberts had attempted to cut her off mid-sentence, his sharp interruption echoing across the chamber like a warning shot. "Congresswoman, that's enough." The words had landed heavily, triggering a ripple of whispers throughout the gallery as heads turned and glances were exchanged. Crockett tightened her grip on her notes, but she did not retreat. She had not come this far to be dismissed. Before her sat 9 justices, appointed for life, elevated beyond the reach of voters. At the center was Roberts, now in his 18th year as Chief Justice of the United States, confident in the authority of his position and the weight of his gavel. To him, Crockett was a first-term representative from Texas, newly arrived on the national stage, someone he likely assumed could be managed or restrained by procedure. But Crockett had spent years as a civil rights attorney and prosecutor. She understood power, and she understood the Constitution. More importantly, she understood that this moment was not merely about courtroom decorum. It was about who gets to speak for the people when their fundamental rights are at stake. She stepped forward, her voice steady and unflinching as it cut through the tense silence. "With all due respect, Mr. Chief Justice, the Constitution does not grant you the authority to silence an elected representative addressing voting rights." The room went still. Roberts's face froze, his expression betraying surprise at the directness of the challenge. This was no longer a procedural exchange. It was a confrontation grounded in constitutional principle, one that questioned the boundaries of judicial authority itself. The chamber remained bathed in formal light as the clerk announced, "The Honorable Court recognizes Congresswoman Jasmine Crockett, appearing as amicus curiae." Roberts gave a restrained nod, his mouth tightening slightly as he responded, "Representative Crockett of Texas's 30th District, you have 10 minutes. His tone was measured, but it carried the unmistakable weight of command. Appointed in 2005 by President George W. Bush, Roberts had long been known for his methodical approach to the law and his acute concern for the court's institutional image. He preferred incremental rulings and careful language, particularly in cases touching on voting rights, an area where his court had repeatedly reshaped constitutional doctrine. Crockett approached the podium with controlled steps. At 42, the Dallas Congresswoman carried herself with the confidence of someone accustomed to adversarial rooms. Her reputation for directness preceded her, as did her record advocating for voting rights and equal protection. She placed her notes on the lectern, looked up at the bench, and began, "Thank you, Mr. Chief Justice, and may it please the court. I appear today not only as a member of Congress, but as someone who has witnessed firsthand the erosion of voting rights across Texas and this country." Her voice filled the chamber, measured but resolute. "The question before you is not merely regulatory. It is whether this court still recognizes voting as a fundamental right deserving of meaningful protection." She paused, allowing her words to settle, then continued. "The case before you, Williams v. Texas Election Commission, concerns voter identification requirements that, on their face, claim neutrality. But constitutional analysis does not end at facial neutrality. It requires examination of effect, context, and history." As she spoke, Roberts shifted slightly in his chair, his expression controlled but alert. This case, he had likely hoped, would remain technical and subdued. Crockett's involvement ensured it would not. Crockett gestured toward the Constitution, displayed prominently within the chamber. When this court decided Shelby County v. Holder, it dismantled key enforcement mechanisms of the Voting Rights Act, assuring the nation that other constitutional safeguards would remain intact. 10 years later, those assurances ring hollow. A visible tension spread through the room as Roberts leaned forward, his breath briefly audible through the microphone. The reference to Shelby County struck directly at one of the defining decisions of his tenure. Justice Elena Kagan glanced toward Roberts, then back at Crockett, her expression attentive. Justice Jackson leaned forward slightly, clearly engaged. Justice Thomas remained still, inscrutable. The ideological divisions of the court were visible without a word being spoken. Crockett continued, her voice gaining strength. The Texas law at issue imposes burdens that fall most heavily on Black and Latino voters. This is not conjecture. It is supported by evidence when nearly 1/4 of Black Texans lack the specific forms of identification required by this law, compared to fewer than 5% of white Texans. We are no longer discussing neutral regulation. We are confronting racial disparity of constitutional magnitude. Roberts interjected, his tone clipped. Congresswoman, please confine your remarks to the legal questions before the court. It was a subtle but unmistakable warning, an attempt to redirect the argument away from racial impact and toward abstract doctrine. Crockett acknowledged him with a nod but did not yield ground. Mr. Chief Justice, the legal question before the court is whether this law violates the 14th and 15th Amendments. That inquiry cannot be resolved without examining its disparate impact. She continued without hesitation. When elderly veterans who have voted for decades are suddenly unable to cast a ballot due to technical barriers, that is not administrative inconvenience, that is disenfranchisement. A low murmur spread through the gallery, quickly silenced by the sharp strike of Roberts's gavel. The confrontation had moved into open view. Crockett laid out her argument with methodical precision, referencing Arlington Heights and the remaining provisions of the Voting Rights Act. Discriminatory effect, when coupled with historical patterns of exclusion, creates a presumption that demands strict scrutiny. Texas cannot meet that burden. Roberts pressed again, his voice firmer. The court is aware of the applicable standards. Please address why this case warrants a different outcome. With respect, Mr. Chief Justice, Crockett replied, precedent is only meaningful when it is faithfully applied. She cited B. Arnovich v. Democratic National Committee, acknowledging the court's prior acceptance of disparate impact while upholding restrictive laws. The severity and scope of disenfranchisement here far exceed what was before the court in prior cases. A ripple of reaction moved through the chamber as Justice Kagan nodded subtly, and Justice Alito frowned. Roberts attempted to reassert control. This court decides cases based on constitutional principles, not policy preferences. The dismissal was calculated, but it opened a door Crock it was prepared to walk through. Then let us speak plainly about constitutional principles, she said. She introduced sworn affidavits from voters across Texas, detailing repeated good faith efforts to comply with the law and their ultimate exclusion from the ballot. She described an 84-year-old woman born in East Texas without a formal birth certificate, turned away because of a clerical discrepancy. She described a disabled veteran denied access due to inaccessible DMV facilities. Each example was tethered to constitutional analysis, illustrating how abstract doctrine translated into lived deprivation. The gallery was silent, reporters recording every word. Roberts interrupted once more. Individual anecdotes do not establish a constitutional violation. Crockett straightened. Mr. Chief Justice, the Constitution exists precisely to protect individuals from systemic abuse. When thousands of similar stories converge into a pattern, they cease to be anecdotes and become evidence. The tension thickened. Roberts reminded her of decorum. Crockett responded calmly. Decorum does not require silence in the face of constitutional harm. She addressed the court as a whole, reframing the argument away from personal confrontation and toward institutional responsibility. How can a law that demonstrably prevents eligible citizens from voting survive review under the 14th and 15th Amendments? Roberts warned her that her time would be cut short. The irony was palpable. Crockett reached into her folder and withdrew a copy of the Constitution. Before my time is ended, she said evenly, it is worth remembering the document that defines both our roles. She cited Article I's establishment of Congress as a co-equal branch and emphasized her duty to represent constituents whose rights were directly affected. Roberts responded that her congressional status conferred no special privilege. Crockett agreed, then clarified, it confers a duty. She spoke of separation of powers, of the founders' intent to prevent any branch from silencing another when fundamental rights were threatened. Several justices shifted in their seats. Roberts issued a final warning. Crockett opened the Constitution to a marked page. The question before this court is whether the promises of the 15th Amendment are enforceable or merely aspirational. She cited data showing hundreds of thousands of eligible voters barred from participation, disproportionately along racial lines. If such a law is constitutional, she asked, what protection remains? Roberts announced that her time had expired. Crockett stood still, composed. Mr. Chief Justice, the Constitution does not authorize the silencing of an elected representative addressing the denial of voting rights. The 15th Amendment exists because those in power have always attempted to suppress voices demanding equal representation. The chamber remained frozen in silence.